This country is completely dysfunctional. And my brother, it's a sad commentary. It is by the grace of the Almighty that we are living day by day. Otherwise, the leadership of this country has completely gone to sleep.
Completely dysfunctional.
My brother, tell me which area of this thing is working in the country today. What is working? Senna, what is working? For the economy to learn order to what and what. Virtually nothing is working.
Well, we do have challenges, but to say nothing is working, is that not a stretch too far?
Oh, Senna, you can cite me at the risk of exaggeration that absolutely nothing is working. But when people say nothing is working, it tells you the depth of despondency. It's functional. It's not working. So now I just indicated to you. Look at many aspects of our national life. Which of them can you count? Can you put your finger on and tell me they are working? Count them for me.
Parliament, for example. At least you have been able to prevent the e-levy. That is one. Of course.
You are talking about those who are not directly under the supervisory authority of the executive. That's what I'm talking about. The acts of those who have been tasked with running the affairs of state. To what extent are they living up to the mandate conferred on them by the good people of this country? That's what I say. Parliament is, you can say Parliament is working in this respect. That is on account of the effectiveness of the NDC group in Parliament. That is what we are citing as working. Not those who have gotten the mandate of the people of this country to run the affairs of state. They are going to sleep. That's what I'm saying. They are going to sleep. Look at the economy. Basa, Nyama. The legendary incompetence of this government has today brought the economy crashing. This is the worst economic performance in a very long time. I mean, to be downgraded by virtually all the rating agencies, Fitch, Moody's, ask all of them, Standard & Poor's, ask all of them, to see category C status, CAA1. My brother, that is junk status. Ask anybody. Since when, under the aegis of the Fourth Republic, when have we come under such very humiliating experience? When? Can anybody tell me? Even the President Mahama that they criticized, they were up in arms saying that President Mahama is incompetent. But we have moved from B+ to B. B+ to B, not B-, even before coming down to C. Look at them. This symbolic performance. Today, the dollar, the cedi to the dollar, the cedi is in free fall. My brother, you just go. Somebody just told me he went to a forex bureau and they told him that the dollar has gone to 8 cedis. Can you believe that? 8 cedis. The people who say they are starting to break the 8. The 8 is breaking them in all places. Fuel prices have already broken the 8. Now the dollar is broken and it's gone to 8. So what kind of Masa, this people you really say is the Almighty Allah. Otherwise, we have asked that what crime has Ghanaians committed to deserve this hopelessly uninspiring government.
And I listen to you, then speak about the latest development, of course, which is attracting everybody's attention. The decision has been made by the Supreme Court. You seem to take an issue with the decision of the courts. What did they get wrong? Why are you unhappy with their decision?
So now to say I'm happy, unhappy is an understatement. In all honesty, it's a disgusting decision. I mean, Master, the ethos calls of the land starts with ensuring justice and fair play in this country. So now I just want to take you back a bit so that you appreciate It's why people feel very angry and anguish about this ruling. You know, as we speak now, the credibility of the judiciary matter is very low. You know, coming from the situation in the past where justice was for sale, where you remember we had this scenario where goods and even yams, cocoa yams and others were presented to some judges, and then they got judgment. I'm sure you are aware. Under the last this where even the Chief Justice had to take very serious steps to try and redeem the image of the judiciary. I'm sure you are aware. So coming from that background, where you need to instill the confidence of the public in the judiciary, you can only do that fundamentally by upholding the law and dispensing justice without fear or favor, ill will or affection, and ensuring that everybody, the principle of the equality of all citizens before the law, is given life to through judgments. No brother. And if you come out with rulings that even everybody can see, I mean, yes, they can argue that this one is a matter of law, but look, the law is also common sense. There are some issues when they come up, people can see it clearly. Like this particular one. Look, it is in the Constitution. It is in the standing orders of the House. The standing orders of the House, Senate, largely are adopted from the Constitution. So those who write the standing orders for approval by Parliament get through the Constitution and extract certain important provisions of the Constitution that confer some powers and authority and functions on Parliament. So those things are largely derived from the Constitution. And so nobody goes to pick anything outside and just comes to act or traverse. So in this particular realm, it is clear. So go and start reading from Article 102 to Article 104. And it tells you that in the formation of a quorum, Mr. Speaker or anybody presiding has no hand in the formation of a quorum. This is in the Constitution. If a judge goes to take that thing and says that he, because he's a judge, he can rule that somebody presiding must of necessity be part of the formation of a quorum. That is egregious. It's an error. That would be a self-serving argument. That is not in tandem with the Constitution. On the contrary, what that judge is trying to do is to throw away a constitutional provision and impose his own views. His own views don't matter. It's the views of is what the Constitution says. So a judge has no right. Let me repeat that. A judge has no right to misinterpret the law. He has no right to throw away provisions and powers and functions that are made available to institutions by the Constitution. So while a judge has the authority to interpret the law, it is not any interpretation that he does that we should take. Because they themselves, that's why even provisions are made for appeal processing, because not only do they err, sometimes they even substitute their own opinions, which may be wrong for what the legal position is. So on this particular matter, respectfully, that is why we say that it was an egregious error. Because the Constitution itself provides, and in clear language, that the person who is presiding is put aside, and the quorum is determined by the members of the on the floor of the House. 1/10 of the members constitute the quorum. So if you are a judge and you come and tell us that the one presiding can be part of the constitution of a quorum, we will tell you respectfully, no. You are substituting your own opinions. You are up to something. That is not the Constitution you are interpreting. You are interpreting something else. And anything coming from you apart from the Constitution, we will not accept it because that's not correct. That is not right.
So you are clear that the Supreme Court was wrong.
Very wrong. It was wrong on this matter. I just ask you, and some of the things that, like I said, you don't need to be a lawyer. Look, it says it's in plain language. Go and read Article 102, and go and read Article 104, and read the standing order 109 3 of Parliament standing orders. Go and read. It says that any of the deputy speakers presiding or any other member of the House presiding shall lose the original vote that he has. So now, what is the original vote? Because it is known for a fact that the first deputy speaker, the second deputy speaker, or any other member of the House elected to preside, originally as a member of parliament, has a vote. So that's the original vote. But when you are transformed from an ordinary member of the House to the status of the speaker, and you take Mr. Speaker's chair, you are robbed. When you come inside, we all get up for you. And they say, Mr. Speaker, and then you say prayers, and you exercise the functions of the speaker. The moment you do all this, you are no longer just an ordinary member of parliament. You have been transformed to the status of the speaker. The speaker is the referee, is the umpire on the House. So now, if you get up and stand and Mr. Speaker decides that you will not speak, he will not call you, you will not speak. Okay? Mr. Speaker exercises functions. So Mr. Speaker is not for nothing that the House says that Mr. Speaker does not take part in the debate. He doesn't take part in the debate because he's the umpire. The referee, at what stage of a match can a referee transform into a player? If they make you a referee. Then the 89th minute, you yourself, your team is not winning, you decide to chase the ball and blast the ball into the net. And we whistle and tell the other team to go and pass. We didn't go and pass the ball. Are you a referee? So that's why the speaker is not allowed to take part in proceedings. So, Senator, how can somebody who is banned from taking part in proceedings, in the debate on the floor, you are not allowed to take part in the debate? How will you be allowed to vote in that matter? Even debate, you can't take part. How less, let alone a vote? So if you get a ruling, in spite of all this, that tells you that they are allowing a deputy speaker to preside and vote at the same time. It's a very funny ruling. It's not based on law. It's not what the Constitution of this republic says. Because the Constitution says it clearly, while you are presiding, you can vote. Why do you now want to come and tell us that while you are presiding, you can vote? Are you a servant of the Constitution or a servant of your own interest? Senator, and on top of that, can you fathom a situation? Look at it. If they had even given more consideration into the matter, they would have seen that this ruling, they shouldn't even issue it. Senator, look at this situation. Mr. Speaker, while he is presiding, he allows a motion to be moved. The motion is seconded. He allows both sides of the House to debate the motion. And at the end of the motion, Mr. Speaker has to put the question. He says, as many as are in favor, say aye. Then members will say aye. Those against say no. They say no. When Mr. Speaker puts the question to members on the floor, Mr. Speaker himself doesn't vote. So let's take this. I want to expose them, and you see the hypocrisy in this ruling. Mr. Speaker puts the question, and people say aye. And then Mr. Speaker now says that there's a challenge to Mr. Speaker's ruling. And the other side, Mr. Speaker says that the ayes have it. So the no say no, Mr. Speaker, we are not happy with your ruling because we think we have the numbers more than the yes people. Then those who voted will come by motion and say that they are calling for a division. A division is an opportunity for the House, which members of the sides that voted, to be counted physically, 1-1-1. So at the end, we know that who has the numbers. So when the division is called for, Mr. Speaker then gets up and says that I am also going to join the yes people and vote. So now, when he, Mr. Speaker, put the question as to those who are in favor say aye, and the ayes said it, did he also say aye? Did he say aye? Because he could not have said aye because he put the question. So if he has not said aye, and you are going to count those who said aye, how will you count the speaker who did not say aye? He was not part of the ayes.
In this case, what the Supreme Court says is that basically when he says those who are in favor for say aye and he is in favor for aye, he can also shout aye.
How can you put the question and get up again and also say aye?
The Supreme Court, I'm guessing, considered that, but they still of the opinion that he can put the question at the same time votes.
Then don't you find that ridiculous? You are sending Parliament into absurd terrain. Very absurd. It has never happened in our history. I'm just saying that there's an argument, and a referee is an arbiter, and the referee decides that no, me, I am here, I'm going to join these people. Are you a referee? At that stage again, are you a referee? I just gave you the scenario. How's a protocol are playing? 89 minutes, the referee, who is a protocol supporter, decides to chase the ball in the 18 of us and blast it to the net. And he himself will whistle. And then you ask House of Folk to go and pass the ball. You think House of Folk will be stupid enough to go and pass the ball? They will not. Because at that time you have abandoned your role as a referee, as an umpire, and descended into the field of play. That is not Mr. Speaker. The moment Mr. Speaker descends into the arena of the play, the house will be ungovernable. He can't manage the house again. Today, if we are told that Honorable Joe Osewusu, who is the Speaker, can vote and can do all this, we will not regard him as a Speaker again. We will treat him like Joe Osewusu, one of us. We treat him as Speaker with all the reverence and respect because he is supposed to be an umpire. The day he says that he is no longer an umpire, he is an MPP man. Going to sit there and do the bidding of MPP, I'm telling you, we'll treat him like an MPP. Is that what the Supreme Court wants us to do? To treat the Speaker like a partisan person from his side sitting on the chair? Is that what they want? Are they not running down Parliament? And look, the Supreme Court is self-ruled. Okay? The Parliament is a master of its own procedure, of its own rules. And so the House has a right which no other organ of government must venture into in bringing out its own procedure for running the business of the House. Have they forgotten that ruling? They themselves made that ruling. And today they are throwing away the procedure of the House, which is governed by the standing orders. And they are not telling us that standing order 109 has been thrown to the dogs. Is that what the Supreme Court is tasked to do? Where did they get that authority from? Even their own ruling. They themselves indicated that Parliament is a matter of its own procedure, of its own rules. Have they been forgotten? So this is a politically motivated decision just to come and help this government, which is in dire straits. It is an attempt to as it were, unduly pad up the numbers of the FPP, which is struggling, which has so badly messed up the economy, and now they want to force the e-levy, which all Ghanaians have described as a very insensitive and wicked levy that they want to impose on Ghanaians. That is what the Supreme Court wants to do now. They are now going to try to descend into the arena of politics to as it were, bail out a hopelessly uninspiring, non-performing government. But the duty of the Supreme Court.
But Honorable, they also have the opinion that what you suggested, taking a member of Parliament, making him a deputy speaker, and virtually depriving him of the role of an MP, which involves him ensuring that on every matter the voice of his people are heard through him as a representative, is unfair. That he should at least have that opportunity to express his opinion in another form, and that should be through voting.
Have they talked about the fact that according to the same person with privileges and other things that he never had before has elevated him to a certain stature, for which he no longer has the right to exercise his functions like an ordinary MP? Have they addressed their minds to that? That Honorable Joseph Wusu coming in as member of Parliament for Bekwai will come and sit with us on the floor. And today, he has to be led by a procession with the mace in front of him. He enters and we all stand up. Look, when Joe Osewusu enters as Joe Osewusu, I will never get up for him. Okay? I will get up for him. When he's coming as speaker, I have to get up for him. He takes the chair. We all stand up. He leads us into prayer in the house. When he is in the chair and I get up to speak, I have to catch his attention. I have to catch his eye before he allows me to speak. So Joe Osewusu can even get the power from ordinary Joe Osewusu sitting on the floor to the speaker where he can prevent me here from speaking. If it's Joe Osewusu, can he prevent me from speaking? But if it's Joe Osewusu as speaker, he can prevent me from speaking. Because if he doesn't give me the opportunity to speak, I can't speak. So you see what the court is oblivious of. They have deliberately decided to ignore those aspects of the elevation of the man and the privileges that have been accorded him. And they're just talking of the representative function for that just one moment. But for all the functions and privileges enjoy, they have conveniently chosen to ignore that. Have you seen the kind of double standards we are dealing with? And so that's why we think that this ruling is self-serving. It is a political decision. And so I'm drawing your attention to the previous, the video went viral. I'm sure you saw it. You may even have it and play it for your listeners. Mr. Ansar Sari, the former director of the Ghana Law School. I'm sure you remember him.
It's a popular video.
Yes, there's a video that you put out that when it comes to political decisions, I'm quoting you. These are not my words. He said that when it comes to political decisions, the judges are timorous souls. That they are not bold enough to look at the law and interpret the law. That what they will interpret is not the law. They will give you their political position. This is what he says. I'm not the one who said it. And this is the former director of the Ghana School of Law, a distinguished lawyer himself. Okay? So this is what I said. Look at this decision that has just come out. This one is a true interpretation of the Constitution of this Republic. When the Constitution says clearly, and the language is not mystifying for any of us. It simply says that the one presiding cannot be part of the quorum. Very simple language. Anybody understand that? Even if I want to go to school, you understand that. You don't need any legal gymnastics for anybody to come and tell us that when the Constitution says that the one presiding cannot be part of forming a quorum, it's clear that the one who is presiding doesn't have a right to vote while he's presiding. You don't need any legal person to interpret that for you. It's common sense. You know it. So why would they come and tell us that things that the Constitution itself? And so it is not for nothing. Go and read from Article 1 to Article 5. The Constitution of this Republic is supreme. In the very opening chapter of the Constitution, it says that the Constitution is the supreme law of the land. To the extent that anybody's actions, utterances, and others is contrary to what this Constitution provides, is up initio, null and void and of no effect. So the fact that the judiciary has been given the right by the Constitution to interpret the law doesn't mean that they can interpret the law anyhow. And so if they make any interpretation that is also falling foul of the Constitution, it's also null and void. Up initio. So those are the issues that come. If the Constitution makes a provision of rights for certain institutions, the judiciary has no right to take those away. Like our standing orders, the judiciary has no right to throw away our standing orders. They cannot. And those standing orders are supported by the Constitution. I just indicated to you that they are derived, and I gave you specific articles of the Constitution where these things are derived from. So how can the judiciary, which is a separate organ of government, interfere with the functions of Parliament to the point that they want to throw away the standing orders of Parliament? It is totally unacceptable.
In the past, when he has attempted to do that, I saw a few members of Parliament, you actually physically stop that from happening. You are saying today that if he attempts that, you treat him like a member of Parliament. I've also heard from your leadership, especially your whip, who is saying that the move first is to seek a review of this decision. Do you think that is something that is worth considering? Go back to the court and saying, you got this and that wrong. Look at this again.
I'm sorry, they are just talking about procedure. That is what the law prescribes. That if you are aggrieved by the decision of a court, no matter how you feel, you have to go through the procedure and apply for a review. But you have a 7-0. My brother, listen to the verdict. 7-0. It is part of the unanimous verdicts we have been hearing. I'm sure you know it. 7-0. So 7-0. What chance of appeal are you making? Except that you are just saying that, fine, let me follow procedure, and then later on, other measures will follow. Fine. I think that is maybe the wisdom of the leadership. We are all, I, as a member of the caucus, I will subsume my personal decisions to the decisions of the caucus leadership. Yes, but I'm sure that the caucus also listens to members before they arrive at decision. So this is a matter I believe our caucus is going to sit down to. But I can tell you one thing. that members of on our side are very, very well positioned and set up to make sure that we do what is right and proper. We are not in any way daunted by this ruling. I can tell you that. Because we are very, very, very straight in our mind that we have a duty to uphold the standing orders of the House. And to the extent that the standing orders of the House are derived by the Constitution of this Republic that has given Parliament those powers and functions. Members, when we get to the bridge, I can assure you, and assure Ghanaians that when we get to the bridge, we will cross it.